Supplementary for judgment, item 1, CRA 63 of 2001.
In view of the foregoing analysis and the discussions made here in our, while this court affirms the conclusion that the deceased met with a homicidal death, the prosecution has failed to establish by reliable and cogent evidence, whether direct or circumstantial, the guilt of the appellants beyond all reasonable doubt. The evidence on record suffers from material inconsistencies and infirmities, which go to the root of the prosecution case and render it unsafe to sustain the conviction. In such circumstances, the appellants are clearly entitled to the benefit of doubt, and the conviction and sentence recorded against them cannot be allowed to stand. In the result, the criminal appeal is allowed. The judgment of conviction and order of sentence dated 13/2/2001, passed by the learned Second National Sessions Judge Cuttack in Sessions Trial Case number 375 of 1999, are hereby set aside. The appellants are acquitted of the charges under Section 302, read Section 34 of the Indian Penal Code by extending them the benefit of doubt. Since the appellants are on bail, their bail bonds stand discharged. They shall be released from all liabilities arising out of the present case if not required in connection with any other case.
I agree.
Pardon to mention, my lord. For judgment, CRA 58 of 2006 with CRA 450 of 2005.
In view of the foregoing discussions, we are of the humble view that the Lennon trial court has rightly found the appellant Kathu Karua guilty. Even though there is no direct evidence in the case, but from the circumstantial evidence on record, it is clearly established that the appellant Kathu Karua committed rape on the deceased, and in order to screen himself from the legal punishment for the offense of committing rape, he killed the deceased in order to wipe out the evidence, and accordingly we hold the appellant guilty under section 376, 302 and 201 of the IPC. Even if there are no independent charges against the appellant Kathu Karua for such offences and the co-accused persons have been acquitted, but since we have come to the conclusion that the appellant Kathu Karua had committed the crime individually, he can be held guilty under such offences implicit in view of the ratio laid down by the Honorable Supreme Court in the case of Kishore Chand versus State of Himachal Pradesh, reported in 1991, 1 Supreme Court cases 286. The sentence imposed by the London Trial Court on the appellant Kathu Karua needs no interference. Accordingly, JCRLA number 58 of 2006, being devoid of merit, stands dismissed. Criminal Appeal number 450 of 2005, filed by the appellant Ramesh Apat, is allowed, and the judgment and order of conviction of the said appellant under section 376(2)(g), 302/34 and 201/34 of the IPC is hereby set aside, and the appellant is acquitted of the charges. It appears that the appellant Kathu Karua was directed to be released on bail by this court by order dated 11/2/2015, and he is now alive as per the written instruction received from the inspector in charge of Yoda Police Station dated 25/10/2025, which we have reflected in our order dated 9/12/2025. The appellant Kathu Karua shall surrender before the London Trial Court within a period of 2 weeks from today to serve out the sentence awarded by the London Trial Court, which is confirmed by us, failing which the London Trial Court shall take necessary coercive steps in accordance with law to take the appellant into judicial custody to serve out the remaining sentence. So far as appellant Ramesh Apat in CRLA number 450 of 2005 is concerned, he was directed to be released on bail by this court by order dated 24/7/2014. Since the criminal appeal has been allowed, he is discharged from the liability of bail bonds. The personal bonds and the surety bond stand cancelled. He shall remain in liberty unless he is required in any other case. Before parting with the case, we would like to put on record our appreciation to Mr. Devi Prasad Bhal and senior advocate appearing for both the appellants for rendering his valuable help and assistance towards arriving at the decision above mentioned. This court also appreciates the valuable help and assistance provided by Mr. B.S. Das Parida, advocate, so also Mr. Aurobindo Mahanti, Lenin Additional Standing Counsel. The trial court records with a copy of the judgment be sent down to the Lenin trial court forthwith for information.
I agree.
Obligation.